Estate planning, imagine that. What gives? Is there any reason your typical younger people should have estate documents? Good question.
Well, Matt, unfortunately, your parents are right. Just because mom and dad are paying your college tuition doesn't mean that they necessarily have the ability to access healthcare information or make healthcare decisions on your behalf in the event of an emergency. So for youngsters, anyone and everyone over the age of 18,
18 is sort of the cutoff age.
18 is the cutoff age. I recommend that everyone over the age of 18 have powers of attorney in place. There are two different kinds. One is for health care, authorizing someone to make healthcare decisions for you, and the other is for property, allowing someone to make financial decisions for you.
Of course, most people that age just don't think about these sorts of things.
I know.
Even people in their 40s and 50s don't think about these things when maybe they should. Let's go back to Facebook. Michael asks, now that the tax exemption is so high, do I really need an estate plan? What do you say about that?
Well, minimizing estate taxes is one of the benefits of addressing estate planning. But for many clients, the driving force is really to avoid probate and provide asset protection for beneficiaries. The exemption that Michael's referring to is high at this point in time. Right now, it's $5.25 million at the federal level, but only $4 million at the state level. In contrast,
so you can protect quite a bit of money compared to 10,
absolutely,
20 years ago.
From a tax perspective.
Right.
In contrast, the threshold in Illinois to avoid probate, which is the court process of administering an estate, is only $100,000. And the problems with probate are really threefold. It's expensive. It's time consuming. Assets are frozen for at least 6 months during the creditor claims period. From my experience, it's much closer to 2 years, and everything becomes a matter of public record.
And you might not get the outcome you were looking for. Mary Jo says, don't name some of your children as executors. Lindsey, is she right about that?
It varies dramatically from client to client. Whomever you're naming as the executor under your will or successor trustee under your trust is a very personal decision. At the end of the day, I encourage clients to think about who they would trust to make financial or administrative decisions. And if that happens to be your children, wonderful. I think what the viewer is referring to, though, is concerns over conflicts of interest. And again, that might vary dramatically from family to family.
Let's sneak one more in. Denise says a friend's husband passed away. He didn't owe federal taxes, but he did owe Illinois taxes. Why did that happen?
Unfortunately, Illinois is a very expensive place to die. As we were talking about before, the exemption amount at the federal level is $5.25 million, but at the state level, it's only $4 million. And what ends up happening is for an individual resident of Illinois who dies here, every dollar in excess of the $4 million, but less than the $5.25 million, is taxed at a rate of 28.5%. So what this means for viewers without estate planning documents, or even viewers who have existing estate planning documents in place that haven't been reviewed, it's critical for them to make sure that their documents correctly reflect this discrepancy, because at the end of the day, it can potentially save more than $347,000.
Wow, that's a big savings. Let's wrap it up with a question from Jamie, who says, my parents said they signed their estate planning documents. Is there anything else they need to do?
So I always advise clients that signing their documents is about 70% of the battle. The other 30% of the estate planning process is to make sure that your assets are properly titled and that your beneficiary designations are correctly updated. Because regardless of what your estate planning documents say, at the end of the day, the beneficiary designations govern. So for clients with existing trusts in place, often referred to as revocable living trusts, a key portion or key step of the process is to retitle assets to make sure that they flow through to the trust.
So the bottom line on all of this is, as difficult a discussion as this may be, and nobody likes to have this discussion, it's something you got to do to avoid probate and maybe lose a lot of money.
Absolutely.
All right, Lindsey.